Hi, thank you for watching Digging to China. I'm Dang Sheng. If you have not done so already, please subscribe to my channel. Thank you very much. The abrupt move by Evergrande to file for bankruptcy protection in the United States has generated a plethora of online comments. However, I believe that many of these comments are merely sensational and lack substance. It's essential for us to comprehend the gravity of Evergrande's decision to seek bankruptcy protection in the US. This significant news development has the potential to enhance our understanding of economic and legal matters. Several questions require clarification. 1. What prompted Evergrande to seek bankruptcy protection in the United States? Second, why did Evergrande opt not to pursue bankruptcy protection in China? As a Chinese company with no real estate developments in the United States, why did they not choose to apply for protection in their home country instead? Providing clear answers to these questions is not a simple task. Many of China's media outlets, including those focused on finance, have not thoroughly explained this situation. This is largely due to the complexity of the matter, which extends beyond their familiar scope and also involves legal aspects in the United States. Here's how the situation unfolded with Evergrande's bankruptcy protection application in the United States. On August 17th, Evergrande Group submitted a request for bankruptcy protection to the New York Manhattan Bankruptcy Court, citing Chapter 15 of the U.S. Bankruptcy Code. This succinctly captures the essence of the news. According to the records provided by Evergrande to the court, their existing US dollar bond issuance stands at a total of $14.2 billion. So, why did they opt for bankruptcy protection from a US court? Based on Chapter 15 of the U.S. Bankruptcy Code, the U.S. Bankruptcy Court can acknowledge bankruptcy cases involving foreign entities or debt restructuring procedures. Additionally, according to Chapter 15, non-U.S. corporations can prevent creditors from filing lawsuits and freezing assets in the U.S., thereby gaining more time for debt restructuring. This explains why Evergrande pursues bankruptcy protection in the U.S. Let's delve into the second aspect. Why did Evergrande choose to pursue bankruptcy protection rather than outright bankruptcy? The disparity between the bankruptcy and the bankruptcy protection is quite substantial. To illustrate, consider the case of H&A Group, which also grappled with insurmountable debt. What transpired with H&A? They opted for bankruptcy protection within a Chinese court, facilitating subsequent debt reorganization. As a result, H&A has now emerged as a leaner, more focused entity. It appears that Evergrande is looking to emulate a similar trajectory as taken by H&A. It's important to grasp the difference between bankruptcy and bankruptcy protection. Bankruptcy occurs when a company can't meet its debt obligations and continue its operations. In such cases, a court mandates business cessation, debt resolution at a complete halt to all company activities. An assigned trustee manages the company's assets, using the proceeds to repay debts and initiate the bankruptcy liquidation process. Essentially, the company ceases to exist. Bankruptcy protection, in contrast, pertains to situations where the debtor, whether financially capable or not, voluntarily seeks court intervention or is compelled by creditors to undergo debt restructuring. Within this framework, the debtor is required to propose a comprehensive debt restructuring plan that outlines repayment terms, methods, and potential adjustments to creditor and shareholder interests. This proposal is subject to a defined submission period, followed by assessment by creditors and a subsequent confirmation by the court. Throughout this process, the debtor retains the ability to continue their business operations. Therefore, the key difference between bankruptcy protection and bankruptcy lies in the fact that under bankruptcy protection, a company's operations remain uninterrupted, regardless of the extent of indebtedness or the ability to repay. The business can continue to function. Furthermore, during the process of presenting a debt restructuring plan, the court ensures the continuous operation of the company. How does the court safeguard a company undergoing debt restructuring? And what advantages does bankruptcy protection offer? The initial advantage is that the court issues a directive to halt debt collection. When a company enters the phase of bankruptcy protection and engage in debt restructuring, creditors are prohibited from further demanding repayment. This offers a period of respite and relief, a goal that Evergrande undoubtedly seeks to attain. The second benefit is that during the period of bankruptcy protection, the court also ensures the possibility of reducing or restructuring your debts. This includes the option for partial or complete debt discharge. Essentially, creditors can negotiate the terms of the debts within the context of the bankruptcy protection proceedings. The third advantage involves asset preservation. The bankruptcy procedure permits debtors to retain essential life necessities and property, ensuring a basic standard of living. These safeguarded assets are termed exempt from the bankruptcy liquidation process. In the case of companies like Evergrande, they understandably desire certain assets to remain untouched, even during the debt restructuring process. This enables them to maintain a fundamental level of sustainability, a protection that the court can also provide. The fourth benefit is that following bankruptcy protection, the entity gains the ability to prioritize debt repayment, deciding which creditors to repay first and which to repay later. This strategy allows them to buy time during the protected period. Overall, obtaining court-approved bankruptcy protection enables the company to secure time for restructuring and maintain external order throughout this period. The third aspect involves the reasons behind Evergrande's decision to seek bankruptcy protection in the United States, primarily driven by two factors. The initial factor is that Evergrande's principal holders of US dollar-denominated debts comprise American investors and institutions. The company is apprehensive that these American creditors could initiate lawsuits or confiscate its assets within the United States. In the event of legal proceedings in the US, Evergrande might confront exorbitant penalties. As a result, the company has sought bankruptcy protection from the US court, with the primary objective of thwarting any attempts by American creditors to demand debt repayment or utilize legal avenues to seize its assets. This stands as their foremost rationale. The second factor behind Evergrande's decision to seek bankruptcy protection in the United States is to send a constructive message to its global creditors, particularly those in the US. It aims to convey its active efforts towards debt restructuring and a genuine willingness to address its financial challenges. This move underscores Evergrande's intention to face its issues head-on rather than avoiding them, reflecting a certain posture of commitment and determination. The fourth aspect involves addressing a complex question. Chinese media have been hesitant to cover this issue, largely due to a lack of understanding. The question pertains to Evergrande, a Chinese company that predominantly defrauded Chinese banks. Why did it opt to seek bankruptcy protection in the United States instead of pursuing debt restructuring within China, its home country? There are four levels of interpretation. Firstly, the bankruptcy restructuring system in China is relatively less developed and mature compared to countries like the United States. This leads to certain challenges and shortcomings. For instance, the criteria for qualifying for bankruptcy restructuring are more stringent. Debtors need to demonstrate a viable prospect for preserving and revitalizing their value, along with the ability to formulate and execute a successful revitalization plan. Otherwise, the case might proceed directly to bankruptcy liquidation. In China, the legal mechanism for bankruptcy restructuring tended to push companies towards outright bankruptcy rather than supporting a comprehensive restructuring process. To put it bluntly, it's not easy to mislead the Chinese courts. If a company is already in dire straits and it claims it wants to rejuvenate or reorganize, it can seem dubious. Chinese courts are quick to recognize such scenarios and are less inclined to grant bankruptcy protection. Instead, they may opt for liquidation. Conversely, the United States adopts a more lenient stance. Therefore, Evergrande's decision to seek assistance in the US rather than in China stems from the fact that the tactics they have employed might find a more receptive environment within the US legal framework. In the US, as long as you provide valid reasons, irrespective of whether your motives are deceitful or genuine, as long as you have objective grounds, you can seek bankruptcy protection. This constitutes the initial aspect. The second aspect sheds light on why Evergrande opted for the United States instead of China. This decision is driven by the more advanced and well-established bankruptcy system in the US, which also boasts several appealing advantages. Section 15 of the US Bankruptcy Code permits foreign enterprise to seek bankruptcy protection in the US for addressing cases of cross-border insolvency. This provision holds significant importance for managing the insolvency of multinational corporations, as it offers a framework that enables foreign entities operating within the US to access bankruptcy protection akin to domestic firms. Given that Evergrande's substantial bond portfolio of over $10 billion was distributed to global investment institutions and individuals, fostering confidence among these investors about their restructuring efforts is paramount. Opting for bankruptcy protection in the US offers a more straightforward path to gaining the trust of these creditors. The third perspective, often overlooked in media coverage, including that of the US media, relates to Evergrande's creditors. A significant majority of these creditors are from the US, primarily composed of US investment institutions. Following Evergrande's financial turmoil, the largest US hedge fund, BlackRock, continued to increase its holdings of Evergrande's bonds. Back in July 2021, amidst Evergrande's crisis, BlackRock aggressively bought Evergrande's bonds, which were then deemed junk bonds. The amount BlackRock acquired totaled $400 million. Notably, BlackRock wasn't alone in this risk-taking endeavor. A high-yield fund under HSBC also purchased bonds worth $31 million. Consequently, in the current pursuit of legal actions and asset seizures, the most resolute among these stakeholders are the US-based investors, facing the most substantial losses. However, considering the situation in July 2021, at that juncture, Evergrande was already grappling with financial crisis and had stopped paying interest on its US dollar bonds. In such a context, the boldness of BlackRock and HSBC in aggressively pursuing these bonds could be seen as speculative. Presently, their endeavors have proven counterproductive. Evergrande's primary concern is shielding itself from these investors, especially BlackRock and HSBC, seeking legal actions or asset seizures. The fourth aspect revolves around a previous instance where a Chinese company pursued bankruptcy protection in the United States and experienced success. Which company are we talking about? It's none other than Luckin Coffee. Following its controversial listing, Luckin Coffee eventually turned to the US for bankruptcy protection, going through a series of twists and turns. Presently, Luckin Coffee has managed to make a comeback. Nevertheless, it's crucial to emphasize that Evergrande's circumstances are fundamentally different from those of Luckin Coffee. Finally, let's explore an intriguing question. What is the official stance of the Chinese government regarding Evergrande's decision to seek protection in the United States? Considering that Evergrande's major creditors are Chinese banks, the situation becomes interesting when the company turns to the US for bankruptcy protection. The eventual decisions made by the US also raised the issue of whether China's central bank and the state-owned banks will still expect repayment. This presents a notable question for consideration. What is China's perspective on this situation? China has taken significant steps in response. As Evergrande seeks bankruptcy protection in the United States, the China Securities Regulatory Commission has officially launched an investigation into the company. The grounds for this investigation are Evergrande's suspected violations of information disclosure regulations. By initiating this inquiry, the CSRC appears to be pressuring Evergrande beyond the legal framework it's seeking in the US for bankruptcy proceedings. This move provides room for the Chinese authorities to potentially reject any rulings made by US courts. In order to maintain control over Evergrande, the Chinese government is employing drastic measures. The unfolding drama surrounding Evergrande's potential bankruptcy restructuring is just beginning. But it's increasingly apparent that the restructuring may not be the ultimate resolution. Instead, the situation appears more likely to lead to delays and eventually culminate in an outcome determined by the Chinese authorities. With Evergrande's staggering debts, a substantial portion of which is owed to Chinese governmental bodies, the central banks, the state-owned banks, it's unlikely that efforts diverging from accommodating their largest creditor will yield meaningful results. Thank you for watching. Please leave a comment and subscribe to my channel. Just click the subscribe button right here. I'll see you again shortly. Until then, be well.